The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. I'd like to welcome counsel and also any of you who are watching on our YouTube channel. We are pleased to be able to bring the argument this morning and this case. We do so, for those of you who may not have watched earlier today or yesterday, I would like to introduce to you our newest colleague, Justice KJ Wall, who joins us for his first docket this week. We are excited to have him with us and as we begin this new period of our court's history. As you all may know, we will soon have another open position on the court due to the impending retirement of Justice Carol Beyer, which is effective this Friday. Because of that rapidly approaching date, Justice Beyer is not participating in the oral arguments this week, but we are very fortunate to have Senior Judge Mike Ward sitting with us. Judge Ward has been serving as our senior judge assigned to the Supreme Court since March of this year. Before that, he served as a district judge in the 13th Judicial District, which is made up of Butler, Greenwood, and Elk counties. We appreciate his service. He will participate in all oral arguments this week, all deliberations, and all decisions in the cases that are argued. So with those introductions, we then turn to the case that we are now hearing and let counsel know that we look forward to their arguments after having read their briefs. With that, I will ask the clerk of the appellate court, Mr. Doug Shima, to please call the case.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Tuesday, September 15th, 2020 consists of one case, appeal number 120503, State of Kansas versus Corbin J. BREITENBACH, Sedgwick County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Counsel, at this time, I would ask for you to please state your appearances and indicate the parties that you represent.
May it please the court, Clayton Perkins appears on behalf of Corbin BREITENBACH, the defendant appellate.
May it please the court, Assistant District Attorney Leslie Isherwood appearing on behalf of the state of Kansas.
Thank you, counsel. Mr. Perkins, you may begin your argument.
Thank you. And in way of sort of procedural background to this case, this is a direct appeal from a jury trial resulting in convictions of attempted capital murder, aggravated criminal sodomy, aggravated rape, and aggravated burglary. Prior to trial, Mr. BREITENBACH requested new appointed counsel to represent him, arguing in particular that his attorney was not investigating his defenses or requesting independent DNA testing. After that was denied, Mr. BREITENBACH represented himself pro se at trial. And I think this case illustrates a breakdown of a lot of the protections of our adversarial system and our adversarial jury trial system. Mr. BREITENBACH was denied the assistance of adequate counsel who would investigate his defenses fully. And then after determining that he had to represent himself at trial, was denied the resources necessary to challenge the state's expert witness evidence and provide him with an adequate defense. And all the while, there was also additional physical evidence, a fingerprint test that was not disclosed, that was exculpatory evidence. Turning specifically to issue one, I think it could be argued that our adversarial system doesn't fully function as and sort of breaks down when indigent defendants do not regularly have the means to obtain independent analysis of the state's expert witness based evidence. But this case goes specifically beyond that premise, because this is a case not only where there was sort of the desire to just check the state's evidence through independent expert analysis, but Mr. Breitenbach was able to show several breakdowns of the normal process and how this evidence would be tested that occurred in the case, that it was rushed, that there were some errors in that process, but also that he was able to present to the district court an expectation of results that he told the district court in the many times this motion or the times this motion was argued that this would result.
Counsel, by rushed, don't you mean prioritized? Or do you have some indication to believe that the actual test itself was done differently than it would otherwise be done?
Well, I think those are in a way the same, because the evidence here is that they were told to put this as a rush job. The investigators from law enforcement told the Regional Science Center, the forensic lab, the crime lab, that they should do a rush job, which was to prioritize it, which resulted in this being sort of taken outside of the normal channels for how DNA testing is done. And it occurred, again, as the lead investigator said, the fastest he had ever seen DNA testing done in one of these cases. So,
do you have any reason to believe the test itself was done differently?
Well, one, yes. I mean, they said they put it as a rush job, which is abnormal, but also there was this breakdown in the way the testing happened, in the way the lab equipment outputted the data that initially caused it to not be readable, which then resulted in the turnaround basically having to do everything over again, and sort of an even more restrained period of time than is typical for these cases. But I think sort of on that point, I think there's a sort of broader concern here with the way this testing is done, because even those errors are errors that are documented in the notes of the forensic scientists who did the DNA testing. But what we're concerned about here is that their test results were wrong, and their notes aren't going to say their test results are wrong, I don't think, if they're acting in sort of a good faith, basis. If there is error in this testing, it was not documented by them because they would correct that error if they knew it happened. And that's why we need independent analysis in these cases, because assuming labs are operating in good faith, they would correct the errors they find. And that's why we need independent experts to review that evidence and test it in this context.
Are you proposing that you should have it simply because you ask for it?
I think that is what the standard should be, but that is not the standard that is necessary for Mr. Breitenbach to prevail in this case. Because the two things that are separating this is, one, that he was able to document unusual circumstances in the testing pattern, which is an area that needs to be investigated. And two, he was able to proffer to the district court what he expected the results to be, which would be complete exclusion of his DNA from the crime scene. That the result that is the only result given to the jury was completely erroneous, is what the expectation is that this DNA testing will result in. Turning specifically to the district court's ruling and analysis here, and the mistake of law that sort of started this premise.
Counsel?
Yes.
Before you do that, can you explain to me what were the documented errors?
Yes. So, well, there were documented sort of unusual testing circumstances in that it was a rush job. The results occurred faster than the lead investigator had ever seen them occur, that there was an additional breakdown of some of the machinery in the testing process. And then we have the sort of statement of the expectation of results here from Mr. Breitenbach. And, as he put it, is that he is factually and actually innocent, and that the DNA, independent DNA testing would show someone else's DNA, not his.
Didn't he arguably back off of that position in the telephone call that he made to his mother?
No, no. Of course, the telephone call occurred first. The telephone call was basically immediately after he was arrested, I believe, and after he had been interrogated by police, invoked his rights. And again, at trial, his argument was that he had just been arrested and was emotionally distraught during that time, which is what caused those statements. And so no, this is his assertions that he's factually and actually innocent is after the sort of removal from that emotional situation and when he is back in court requesting an investigation in his defenses. And I think the first issue in this ruling for this DNA evidence was the district court's reliance on volume 19, page 16. The district court laid out their test, which is whether or not the defense has set forth a valid basis to question the reliability or accuracy of the state's DNA evidence, which is not the statutory test in 224508, which is referring to what's necessary for an adequate defense. It's not the, Ninth Circuit type adoption of the federal rules, which is asking is reasonably competent counsel would require the assistance of the requested expert. It's not the constitutional rules that look to whether or not this would be a significant defense at trial or a significant issue. And it is not it's not consistent with any of the standards. And in fact, it's a much higher standard, particularly if we are talking about whether or not the state's evidence is unreliable. We're talking about whether or not that would be admissible at all under our expert witness statutes. And that's something that would be looked at a Daubert hearing, at which point you would already have experts by the defense that would be reviewing the evidence and challenging that evidence. This is, a standard that is meant for investigation, for the first steps of establishing the defense. And as sort of the Ninth Circuit case law looks at, the way the district court analyzed this runs this catch-22 risk that if the standards for getting defense experts are so high that you would really require experts to get their testimony challenging the state's evidence to even get an expert appointed in an indigent case, you're never going to get this. It's impossible, and you're not going to get defenses investigated.
But didn't the judge also talk about the test of necessary to the defense? It seems like this question about the reliability went only to the retesting of the two pieces of evidence that had been tested. And so he was looking at why would we question why it was necessary to the defense to have a retesting of those. But in speaking to the more global request for additional testing, at least in context, it appears that the judge is talking about where's the evidence, where are you meeting your burden that it's necessary to the defense? And I know earlier you said your suggestion is all the defendant should have to do is say that and should have to go no further. But is that the law, that there really is no showing that must be made?
No, that is not the law. That is the law that I would prefer, but that is not the law, and that is not the standard that Mr. BREITENBACH meets in this case. He meets the higher standards of whether or not adequate counsel would look at this, given that there is evidence, statements that his DNA cannot be on that crime scene because he is factually and actually innocent, and how you would sort of challenge that evidence. And the core of that is retesting these specific samples. Of course, he is requesting also testing of all of the samples or more of the samples as sort of a thoroughness here. And of course, there was a confusion initially, which is sort of tied to our post-conviction DNA testing statute, because initially Mr. BREITENBACH says at the hearing he doesn't think you can get retesting, which is the case with our post-conviction DNA statute. But when the judge clarified that that would be available, he said, well, yes, of course, I want these samples retested because that's going to be the core of challenging the state's case. And is, sort of, I guess, to wrap this up as my time is ending is one of the things that I struggle with and I'm bothered by with this case, which is that there is post-conviction DNA testing that almost does provide a broader protection of or access to testing than was provided in this case. In fact, there were statements of, yeah, let's deal with this as a post-conviction matter, but we rely on the adversarial process, the meaningful testing of evidence to give us fair trials. And this was the actual timely request of evidence that would be exonerating under the evidence that, or the proffers that were presented to the district court. And that is, I think, a denial of a fair trial in this case. Thank you.
Are there questions?
I just have just a real quick question, and it's not just in regarding to your last issue about exculpatory evidence. When was the general discovery motion filed regarding the fingerprints in conjunction with the trial?
There were, I believe, several, because there were both Mr. Smart, his, appointed attorney back in what would have been January then, had filed a number of sort of form motions, including requests for discovery. And then Mr. Breitenbach, I believe, also filed a pro se request for discovery. So I'm not, I apologize. I'm not
No,
sure.
no, that's okay. I was just wondering how, in conjunction with the trial, where was that request made, and your complaint that the information wasn't turned over until the second day of trial? I'm just wondering how much time lapsed between the request and the actual disclosure of the requested information.
So I can say that it would either be, I believe, volumes 8 or 11 were when Mr. Breitenbach brought it up, the fingerprint evidence up on the record.
Okay, that's fine. If you don't, yeah, that's fine. Thank you.
Mr. Perkins, the fingerprint report that I'm looking at says the print was reevaluated and deemed not of value for identification. How is it that you characterize that as exculpatory?
Because the proffer in the report starts off with the print was graded of value, submitted to APHIS, compared to both Mr. Breitenbach and the network. And it was only after those were exclusions that it was regraded and deemed of no value, so it was sufficient for testing. And it was only after it was exclusive to Mr. Breitenbach that it was reevaluated.
Did the jury have the benefit of this information ultimately?
No, the jury did not have the benefit of this information. They only had information that it was tested and graded of no value.
Okay. All right.
But counsel, was that a choice of counsel? That was not before the jury? I mean, they had the opportunity, right?
In the sort of unusual context of this case, I think I can certainly say that it did not have the opportunity. The way the evidence came in, it was as sort of after the reports came out, as after the state's evidence, those witnesses, I'm not even sure we have the witness who testified who did that test. I can't recall whether or not that was, no, because the investigator and the other person only said graded of no value. So I don't think they were the ones that actually did the test. And Mr. Breitenbach, as a pro se defendant, didn't have sort of the opportunity to, last minute rush to subpoena any expert witnesses. The evidence was not presented to the jury, though it was entirely consistent with his defense.
Mr. Breitenbach did not ask for additional time, correct?
Not that I'm aware of.
Other questions? Thank you, Mr. Perkins. Ms. Isherwood?
May it please the court, Assistant District Attorney Leslie Isherwood appearing on behalf of the state. And primarily we will be confining our argument today to the first issue, but I do want to kind of go unconventional and pick up with this last issue that we talked about a little bit with respect to the fingerprint, just so that I have an opportunity to kind of flesh out what I think some of the questions are pertaining to. And the question was just presented whether there was an opportunity for that information to come before the jury. And it is my understanding from the record that that report was provided to the defendant prior to the close of testimony when he was still questioning the lead investigator in this case, Detective Waite. So to say that there was not an opportunity to present this to the jury, I think is kind of misconstrues the record a little bit. And then to further say that the defendant did not have the opportunity to secure witnesses, the court had taken measures to ensure that the defendant had an investigator, Mr. Shalaki, assigned to him from BIDS, who was instrumental in the defendant being able to contact witnesses and do some of the investigations that he needed to do. So A, that information was still available to be presented to the jury, and B, to the extent witnesses needed to be located, the defendant did have an investigator at his disposal who had been working in that capacity.
Yeah, I appreciate that, but I guess my question having to do with the timing, you seem to minimize the fact that this was disclosed during trial and it was requested well before trial. And I understand the subsequent prejudice might not be so great, but the point is that the request was made, and in preparing for trial, shouldn't any defendant or any accused have the information that's requested, especially when it pertains to fingerprint evidence, which is pretty significant in this case. It's pretty important. And why wasn't that? What's the delay here? And this is a major case, a major trial. And it just seems to me the state ought to have its ducks in a row and disclose this information well before trial.
At the time that the disclosure or that this came to light during the testimony of Mr. Westfall, who was a crime scene investigator, the state was not aware that this fingerprint had been collected or examined either. So as it was news to the defendant, it was also news to the state. And the state automatically made contact that evening and learned that it had been tested, but that no report had ever been generated. A report was automatically prepared as quickly as possible and was then made available to the defendant. So how that was not disclosed at the time that that exam was done, I don't have an answer for that. But what I can say is that while it did not link the defendant to the scene, I wouldn't necessarily say that this was exculpatory information because it wasn't complete for testing.
I guess that, but yeah, I understand that it might not be exculpatory, but the point being is that should, anyway, you got my point, but thank you.
Sure. If there are no further questions on that issue, I would like to circle back and start with the first issue, which challenges the exercise of the district court's discretion in denying the defendant's request for expert services. And under the standard, the district court's ruling on this matter will not be overturned absent a showing of substantial prejudice to the defendant's rights to a fair trial. Prior to trial, defendant filed a motion pursuant to KSA 22-4508 requesting expert services to analyze the DNA evidence that was collected in this case. According to that provision, the district court must make two determinations: whether the defendant is able to afford the services that are requested and whether those requested services are necessary to an adequate presentation of his defense. The question before this court focuses on that second factor, whether the question of necessity. And the first prong of the defendant's attack is that the court's ruling was a mistake of law because it employed the wrong legal standard. However, if we look at the hearing that the court conducted on the motion, as well as its comprehensive ruling, both of those were tailored to the language of 22-4508. The appointment of experts is not constitutionally required. In State versus Lee, this court held that the state is not required to furnish a defendant with all the services that are available to the state because to do so would essentially be an impossibility. Ake and Caldwell, which are United States Supreme Court precedent on this matter, have also spoke in terms of limiting languages, that it may well be crucial or that they are required to provide services when there is a need for the same. A fair review of the hearing conducted in this case and its ruling shows that the court analyzed this through the appropriate legal lens. Defendant likewise alleges an abuse of discretion, claiming that a mistake of fact occurred, specifically that the court erred in finding that the Science Center was an unbiased entity, and also that the court erred in finding that the defendant had not specifically stated what he was seeking and what he anticipated that assistance would provide. For his first claim, the defendant argues that the lab cannot be viewed as unbiased because they receive lab fees in certain cases. So they have a vested interest in these convictions coming to fruition. There's simply no foundation for that claim. The Science Center is a public entity that yields inculpatory and exculpatory evidence alike. It is no more an arm of the prosecution than any other public entity that plays a role in the investigative process. The defendant's second claim arises out of the court's finding that the defendant failed to specifically articulate what these independent services would provide. The transcript of the hearing reflects that no assertion was made calling into the credibility or the specific reliability of this testing, or what specific DNA testing the defendant would like to have done on the evidence that remained. He simply wanted to explore whether human error may have occurred, even though he, quote, didn't have any evidence to support that accusation. And that he shared with the court at record volume 19, pages 12 and 13. 224508 is not intended to be a gateway for fishing expeditions, and that's what the district court was seeking to avoid. In Caldwell, our United States Supreme Court said that where Mr. Caldwell offered little more than generalized assertions as to what the requested assistance might yield, there was no deprivation of due process. The precedent surrounding this area reflects that a defendant must demonstrate something more than a mere possibility that the requested services will be beneficial. They must show that there exists a reasonable probability that both the requested expert would be of beneficial assistance and that the failure to provide it would result in a fundamentally unfair trial. The motion in this case, when considered in light of what was known to the judge at the time of the hearing, which was the DNA evidence collected from the victim's body linked to the defendant to this crime, the fact that the victim had made a positive identification of the defendant through a photo lineup, and the fact that the defendant had confessed to his mother the day after he was arrested that he was, quote, the monster that committed these acts against this young girl. With that background, in the court's mind, the defendant failed to create a reasonable probability that expert assistance in the form of DNA testing was necessary to the defense, and that without such, his trial would be fundamentally unfair. In this case, the defendant was inculpated by evidence that indicated his DNA was collected from the 7-year-old's body. Her blood was found on the tongue of his tennis shoe. He was staying with a girlfriend in an apartment adjacent to this apartment building, and his whereabouts were unknown at the time of the attack. He had told his mother he was responsible for this attack, and the young victim positively and unequivocally identified the defendant as her attacker from a photo lineup. Against this backdrop, it cannot be said that the ruling of the district court on this matter resulted in substantial prejudice to the defendant's case. If there are no questions on that issue, we would submit the remaining issues on the brief, and the state would respectfully request that the decisions of the district court and the defendant's convictions be affirmed.
See no questions. Thank you, counsel. Mr. Perkins, you reserve 3 minutes.
Thank you. just to go back to Justice Rosen's question earlier about the timing, volume 11 is where Mr. Breitenbach mentions how he wants the fingerprints tested. Quote, "I'm sure it doesn't take a lot of time to run it through the computer," when in reality it had already been run through the computer, but that wasn't discovered until trial, which was September 2018. Volume 11 was February of 2018. To go back to one of the topics, which was this question of bias, and specifically, I think the mistake in here is the sort of contrast the district court had between a civil trial where each side would have their own experts and they would sort of have their own bias to the side that they are being called by. And my point is that these are the state's experts. That same bias exists. It's not an inappropriate bias. The state is a public entity. As a public defender, I'm part of a public entity. We are both biased to this because we exist in an adversarial system. That bias is not unusual, but it is problematic when the district court is relying on this as if they are a neutral body like the courts are. The crime lab is not a neutral body like the courts. And sort of to wrap this up, there's, I think, one thing that bothers me about sort of some of the argument or the way this argument plays out is that the state relies on, say, the weight of evidence against Mr. Breitenbach that they say they can put forth to say that it should be appropriate to cut off the investigation of his defenses. We don't, but I don't think our adversarial system works when we aren't allowing meaningful investigation of the defenses, even if there is overwhelming evidence. But in this case, there is not overwhelming evidence. There are a number of problems, both with the evidence here and with evidence that Mr. Breitenbach was actually able to show in his defense at trial. Of course, there's the issue with the DNA testing that it was never challenged in our adversarial system. The state wants to rely on a 1 in 107 octillion result, but the defense was not allowed any way to meaningfully review or challenge that despite the requests. Of course, there's the shoe evidence, but the defense was able to put forth a witness, Miss Fowler, who saw Mr. Breitenbach during this 10 to 25 minute window when this crime must have occurred, and said he was wearing white clothing and white tennis shoes. And this drop of blood occurs on a black, gray, and white tennis shoe that was found at a different location far later in time with a 1 in 5 exclusion rate to Mr. Breitenbach. There were other suspects that were not investigated in this case, including someone who had broken into that apartment through that route before. And of course, there is this fingerprint that was identified by investigators as the spot where the assailant would have broken in, that was tested and excluded Mr. Breitenbach. And of course, that piece of evidence not only mattered to his trial defense, but was yet another instance where Mr. Breitenbach was able to point to physical evidence that should be tested that would not be consistent with him, and it wasn't. And I think those collections with what happened here denied him a fair trial and requires reversal of his convictions. Thank you.
Thank you. Any questions of counsel? I don't see any. Thank you, Mr. Perkins, and thank you, Ms. Isherwoods, for your arguments. The court will take this matter under advisement, and we will now be in recess until 1:30 this afternoon. Thank you.